Hello and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and today we are going to discuss a very important extraordinary power that has been given to the Honorable Supreme Court of India. The title of our today's discussion is Article 142, Power to do complete justice by the Supreme Court of India. So in this discussion, we will be studying about the power of the Supreme Court to do complete justice. We are also going to see the scope and extent of the power granted to the Supreme Court under Article 142 of our Indian Constitution. We are also going to see some of the important criticisms against this power, and in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if we talk about the background of our today's topic, the Supreme Court in a recent judgment has held that it has the power under Article 142 to grant immediate divorce to a couple, and this can be done in order to do complete justice when the marriage has broken down irretrievably. So if the marriage is completely broken down and it is not possible for the partner to just even spend one day with the another partner, then they can directly approach the Supreme Court, and the Supreme Court, keeping aside the normal procedure. In the normal procedure, the couple has first to approach the family court for mutual consent divorce, and the time period is minimum 6 months and maximum 18 months. So the Supreme Court is empowered under Article 142 to waive off this condition of divorce by mutual consent and can grant the divorce directly as well. So if we understand the power of the Supreme Court to do complete justice, it entitles the Supreme Court to pass a decree or to make an order for the purposes of doing complete justice in any cause or matter pending before it. So this is a very important extraordinary device given to the Honorable Supreme Court of India. What happens is that sometimes the litigants are running for justice from pillar to post, yet they are not able to secure the justice, and hence the Supreme Court has to intervene in those cases and has to do complete justice to the litigants in those cases, and that is why this power has been granted by our founding fathers to the Honorable Supreme Court of India. And if we talk about the history of this power under Article 142, it was Article 118 in the draft constitution which was presented before the Constituent Assembly, and it was adopted as it is under Article 142, namely Article 142, without any debates, because our founding fathers were cognizant of the fact that Supreme Court will have to intervene in some extraordinary circumstances, and justice delayed is justice denied, and this concept was recognized by our founding fathers, and that is why they did not debate on this power and adopted it as it is. So this, if we talk about the scope and extent of this power, it is very wide in nature. In fact, the Parliament also cannot limit this power. The Parliament cannot also say that, okay, we'll bring an amendment and suddenly the Supreme Court will not have this power. No, this is not the case. It has very wide powers. The Supreme Court power under Article 142 cannot even be watered down by our Indian Parliament. The court has given a broad and a purposive interpretation to this provision. So if we talk about the interpretation of the power and to do complete justice under Article 142 of our Indian Constitution, it is very broad in nature. The Supreme Court, through catena of judgments, has increased its scope, and now it also empowers the Supreme Court to directly grant a divorce, as we were discussing in the background of our today's topic. And it is a purposive provision. It has some purpose. It has a purpose to secure the ends of justice, and that is why the Supreme Court has given so wide powers. And if we talk about the scope and extent of the powers of under Article 142 of our Indian Constitution, so the normal scope is it is very wide in nature, but the question comes here is, can it violate fundamental rights? Can it violate Article 32 of our Indian Constitution, can it violate the substantive provisions of the law that have been enacted by our Indian Parliament? So the answer is no. And this was held in the case of Premchand Garg case. So while defining the scope of power under Article 142, the Supreme Court in the Premchand Garg case has categorically held that the power under Article 142 cannot run against fundamental rights. It cannot also be inconsistent with any substantive provision of law that has been enacted by our Indian Parliament. So while doing complete justice to the parties, under Article 142, the Supreme Court has to take notice of the substantive provisions of the law which has been made by the Parliament, and it also cannot run against Article 32 of our Indian Constitution. Then in the case of Bhopal gas tragedy or the Union Carbide Corporation versus Union of India, the Supreme Court held that prohibitions or limitations, this is or, on provisions contained in an ordinary law cannot ipso facto act as a prohibition or limitations on the constitutional powers under Article 142. So see the broadened scope, see the wide scope, see the interpretation which the Supreme Court is given to its power under Article 142, that ipso facto. What do we mean by ipso facto? By the fact itself. By the fact itself, there is a substantive provision. It cannot act as a prohibition or limitation on the power of the Supreme Court under Article 142. Though the Supreme Court also is duty bound to consider the substantive procedure of laws, as we were discussing in the Premchand Garg case, that it cannot run inconsistent with the substantive provisions of law, but those substantive provisions of law also cannot limit the scope of Article 142. Adding that, it would be wholly incorrect to say that powers under Article 142 are subject to express statutory prohibitions. The court reasoned that doing so would convey the idea that a statutory provision comes above the constitutional provision. So in this case, the court held that no statutory provision could override the power under Article 142 because prohibitions or limitations in any statutory provision cannot override or cannot bottle down the constitutional provision of Article 142. And the case of Premchand Garg, the judgment in the case of Premchand Garg was affirmed by the Supreme Court in the case of A.R. Antule versus R.S. Nayak. So this is a very landmark case, A.R. Antule versus R.S. Nayak, and the Supreme Court in this case has reaffirmed its judgment in the Premchand Garg case. So if we talk about the use of or the interpretation of Article 142 in some of the recent cases. So Article 142 was also used in the Rajiv Gandhi assassination case to release the convict because the convict in the Rajiv Gandhi assassination case was arrested only when he was 19 years old. So the Supreme Court, while exercising Article 142, released him from prison and said that he has served enough of his time in jail and he should be released. But this move was often criticized by the Congress government. Then the Babri Masjid case. The article was used in the Ram Janmabhoomi Babri Masjid land dispute case and was instrumental in the hand of the disputed land to the trust that was constituted by the union government. So this article also came to play in the recent case of Babri Masjid case, and in this this article was used to hand over the disputed land to the trust formed by the government of India. This article was used to do complete justice in this recent case. So if we talk about the criticism against this power of the Supreme Court, so the first and foremost criticism of this power of the Supreme Court, that it is very arbitrary and ambiguous in nature. Why are we saying that it is arbitrary in nature? Because there is no limited scope of this power. No one is maintaining checks and balances of this power of the Supreme Court. In India, we have a vertical distribution of power. Which means that the legislature keeps a check on the executive, and a check has to kept by both of these organs on the judiciary as well. So it is often being argued by the critics that the power is very arbitrary in nature because it gives Supreme Court the utmost importance. There are no checks and balances against this power of the Supreme Court. There is no internal safety valve. Internal safety valve of against this power of the Supreme Court under Article 142. So the Supreme Court can also use this power in an arbitrary matter and can judicially overreach the functions of the legislature. But this is not true if we talk about the checks and balances of this power under the Supreme Court under Article 142. The court itself maintains the checks and balances. The court in the case of in 1998 in the case of SC Bar Association versus Union of India. So in this 1998 judgment of SC Bar Association versus Union of India, the Supreme Court has itself put a limit on the power, its power under Article 142 by holding that this power is only supplementary in nature. It is curative in nature and it cannot be used to supplant or override the substantial provisions of law. So this is a bit incorrect to say that there is no checks and balances on this power of the Supreme Court. Why? Because the Supreme Court is only maintaining the checks and balances through its various judgments. And why are we saying that this power is ambiguous in nature? Because the interpretation of this term complete justice varies from case to case. It is very subjective in nature. There is no definite interpretation of this term complete justice, and that is why the critics argue that this power is very ambiguous in nature. Some of the other criticisms of this power under Article 142 are: unlike the legislature and the executive, the judiciary cannot be held accountable for its actions. Why? Because the parliament is not empowered to discuss the conduct of the judiciary on the floor of the House of the Parliament. And until and unless the impeachment proceedings are going on, the parliament is not empowered to discuss the ordinary conduct of the judges or the courts on the floor of the houses of the parliament. And that is why it is also argued that this power completely puts Supreme Court above the parliament. Why? Because they cannot be held accountable for their actions. For example, in the ban on sale of alcohol on the national highways, there was a statutory law made by the central government, but the Supreme Court saying that alcohol cannot be sold within a distance of 500 meters of the national highway to stop drunk and driving, clearly overreached into the power of the legislature. And that is why, and there is no accountability for the Supreme Court in these matters. Violation of the doctrine of separation of powers. So India follows the doctrine of separation of powers between the legislature, executive and the judiciary. And the critics often argued that the power granted to the Supreme Court under Article 142 is clearly a violation of the doctrine of separation of powers because it facilitates the judicial overreach. This means the judiciary can overreach into the legislative or the executive function, and the recent case law of this ban on sale of liquor within 500 meters to stop drunk driving, even after there was a law proves this, that the judiciary often, to practice judicial activism, often steps into the shoes of the legislature. So the critics also argue that this power under Article 142 of our Indian Constitution is violative of the doctrine of separation of power. Why? Because the judiciary itself is saying that no parliament power can limit or put a prohibition on the power of the judiciary under Article 142. With this, we come to a conclusion of our today's discussion. We have seen the power of the Supreme Court to do complete justice. We have also analyzed that it has a very wide scope, and we have also seen the criticism against this power of the Supreme Court. Now let us see a practice question for your prelims examination. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following, and this is a PYQ. This question was asked in your GS paper 2019. So your statement number 1 is, the decisions taken by the Election Commission of India while discharging its duties cannot be challenged in any court of law. Your statement number 2 is, the Supreme Court of India is not constrained in the exercise of its powers by law made by the Parliament. Statement number 3 is, in the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the Cabinet. Then statement number 2 is, state legislatures cannot make laws on certain matters without the concurrence of Union legislature. Kindly drop your answers in the comment box below. Now let us see a practice question for your mains examination. Discuss the pros and cons of Article 142 of the Indian Constitution. So you will introduce what is Article 142 of the Indian Constitution. In the introduction, you will state about the power of the Supreme Court to do complete justice. In the pros, you can write that this is a very important power that can be exercised in any case of emergency, because justice delayed is justice denied. Parties come to the court for achieving, securing justice, and the Supreme Court has the power to do complete justice in any cause or matter pending before it. And this power of the Supreme Court exists apart from the law made by the Parliament, and it is supplementary to the other powers given to the Supreme Court. Then in the cons, you will write this is a violation of separation of powers. This is very arbitrary and unambiguous, and you will also say that judiciary cannot be held accountable for this the actions they take under Article 142. So you'll write all of these in the pros and cons of Article 142. Then you can conclude that this power also, although it has a wide nature, but is often used by the judiciary only in emergency cases, when they see that the law made by the Parliament is not sufficient to do complete justice between the parties. So we'll also draw out the importance of inserting this article in the Indian Constitution in the conclusion. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you found the today's discussion helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.